Welcome to the latest episode of Call to the Bar, International Law Over Drinks. I'm your host, Dr. Tamsin Philippa Paige, Associate Professor at Deakin Law School. Today we are discussing the venue of the courtroom in international criminal law, how it occupies a space of punishment rather than accountability, and how that punishment often eschews rehabilitation of offenders in favour of the punishment, which is something we've touched upon before with Kate Gibson in episode 55 and with Sanam Amin and Sophie Rigney in episode 79. We're also looking at how the courtroom itself is a site of violence and the reluctance of too many feminists to hold women who commit atrocities to account. Joining me for this discussion is Dr. Caitlin Biddolph, lecturer in international relations at my alma mater, the University of Technology, Sydney, and Professor Olivera Simić of Griffith Law School, both of whom have worked extensively on these sorts of questions in the context of the ICTY. But before we begin, I remind everyone that in these informal conversations, we are, as always, speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. But before we get down to business, our traditional first question, Ollie, Caitlin, what's your drink?
It's 11 a.m. here in Brisbane. Hello, everyone. Good morning or early afternoon. Good early afternoon. I just have a plain glass of water, so pretty boring.
No, that's fine. Got to stay hydrated.
Yeah.
Hi everyone. First of all, I'm joining from Darug and Guringai land around Sydney, Australia. And this morning I have a spiced apple and chamomile tea, which is quite nice on a cold, rainy day. Usually I've had my coffee already, so I try to keep it to one per day. So
You are better than me. I'm on my third coffee now. So yeah, I have coffee as we've just alluded to. It's a drip filter as is my usual. Patio coffee from Adelaide's Carousel blend, which is a blend of Brazilian and Colombian beans with notes of walnut, apricot, and cinnamon. It's kind of delicious, and I'm digging it.
sounds delicious.
Yeah, no,
You'll
and
have to send me a link to that, to those
yeah,
things. Yeah.
absolutely. I swear by patio coffee. I discovered them when I was living in Adelaide during my doctorate, and I just get them to ship me beans now to make my coffee delish. And your tea sounds delicious as well. So, we're all good on this
Well,
front.
basic twinings if people are interested.
I'll forgive you for the tea bag just this once. Now, neither of you have been on the pod before, and we usually start by asking new guests, how did you get into international law and what career path brought you to your present job?
Shall I start?
Go for it.
All right. So this is a huge question. I can spend probably the next 2 hours talking just about this because I think it's a very important question because it gives us perspective on how people ended up doing what they're doing. And I think most of the people have some sort of personal circumstances, backgrounds, or something, that happened that made them passionate to take this path. So in my case, as in many other cases, I think it was a combination of circumstances. I certainly never dreamed of being an academic or writer. And on top of that, living and working in Australia, kind of 16,000 kilometers away from my homeland. So when I finished my high school, I applied to study psychology, and then the war broke out in my homeland, which is the former Yugoslavia. So instead of beginning my studies in Sarajevo, as planned with my best girlfriends at the time, I found myself as a refugee in a neighboring country studying law. So I started a law degree in Bosnia, and one of the several reasons I left late 1992, the war started in April 1992, or fled basically the country and my hometown, was I received a draft. And I think this story is very important to be told. I received a draft into the territorial defense. And I still remember very vividly the day when I went with my father to pick up, it was a blue uniform and black boots. And this is still one of many untold stories about the war in Bosnia and Herzegovina, that young women were called, not necessarily, they were not drafted into the war, but they were called on some sort of duty to perform various duties in this war effort. And I was 19 at the time. My brother was 22 back then. He was already drafted into the war. And of course, my parents freaked out when I was about to, be drafted in territorial offense. And the prospect of their second child, a daughter, being dragged into the war was just out of question. So they put me on the bus and I ended up 800 kilometers away from my hometown in another country and city I had never been before. I lived in a refugee camp while attending university, and took me double more time to finish my law degree. As you can imagine, it was incredibly difficult and hard to concentrate on exams while following and going through everything what was going on back then. Somehow I persevered through all of that and finished those studies. And then I went back to Bosnia, and I worked for some time with United Nations, with UNICEF, on human trafficking, and then enrolled masters in international human rights law in the UK on scholarship. Otherwise, I would never be able to enroll and do my master's. And really, I was driven by desire and urge to understand what had devastated my country, because at the time when it happened, I did not fully comprehend what was really unfolding around me. So I witnessed ethnic cleansing as in my hometown, as many of my friends who were non-Serbs had to or were expelled from our hometown. But I could not articulate those experiences and had no language to describe them in 1992 and between 1992 and 1995. So I think I was probably too young and in some kind of shock, and everything was happening too fast, too sudden from my perspective, at least. So one day we were just young people hanging out and, planning what to study. And next day, most of my friends were gone. Some of them were drafted into the war and were killed, and the others fled the country and became refugees. So I think, this urge to understand what really happened, how was all this possible to happen, is something that I probably spent all my post-war life trying to make sense of these events and to understand them, to heal from them, and kind of help others to find some healing and justice. And I think in many ways I'm still kind of doing so. So over those years, that journey took me to different parts of the world, to where I lived, studied, and worked. But I think one of the most transformative experiences was, I think, studying in Costa Rica at the United Nations University for Peace. I don't know how many people have heard about this university, and that is in Costa Rica because Costa Rica is renowned for its historic decision to abolish its standing army in 1948. Well done, Costa Rica. So what Costa Rica did was, rather than maintaining a military, their successive governments prioritized investment in healthcare, education, and social welfare, making the country kind of internationally recognized example of development without a standing army. So because of that, United Nations decided kind of symbolically recognize this effort, and University for Peace was established by the UN General Assembly in the 1980s. So studying there along hundreds of students back in 2002, 2003, from around the world was really extraordinary experience that profoundly shaped my thinking about peace, gender, and justice, because I did a course in gender and peace building. And that's going to be the first time I'm outside of the country, outside of the Bosnia or former Yugoslavia after the war. And the first time I actually am facing the people who are talking about my homeland and Bosnia as a case study for mass atrocities. So it was very, very challenging time for me. And the first time that I'm going to start thinking and talking about my experiences with war, because I didn't have time. I was just running, for survival basically over all those years. And then I stopped there. And that was the first time I actually faced all these things and read cases and judgments and everything else, what was coming about former Yugoslavia and the wars that occurred over there. And after I did a master's in international human rights law in the UK, I did a second master's in Costa Rica in gender and peace building. I was, going back and forth between these countries and continents back to Sarajevo. And then somewhere in the back of my mind, I decided that I wanted to leave kind of country for good, and I wanted to pursue my education elsewhere. And I was lucky to get another scholarship and enrolled PhD at University of Melbourne, where Professor Di Otto became my supervisor, very important mentor and lifelong friend. And Di not only supervised my doctoral research, but also really helped me to settle in Australia and in many ways find inner peace here. And I began publishing during my PhD, drawing on both my personal experiences with war and, academic interest in mass atrocities, international criminal law, and transitional justice. So those two strands, my lived experiences and my scholarship, have remained intertwined ever since. So writing to me became kind of way of understanding the past, giving a voice to those whose stories had been overlooked, and contributing in modest way to conversations about justice, memory, accountability. And this is how I came into the field, and here we are.
That's it's a heavy story. Like, I'm not gonna lie, it's a heavy story, and I really appreciate you sharing that with us. And yeah, look, as someone who's also been mentored by Diotto, I can speak very fondly of such a wonderful, both scholar and mentor and friend that she is. So yeah. Caitlin, it's a hard act to follow, but tell us about your journey to international law.
Yeah, thank you. And yes, thank you so much, Ollie, for sharing that with us and obviously to the listeners as well. It's such a meaningful journey, and I do feel a little bit inadequate with my own journey to international law. But I often say in these circles, first of all, that I'm not a lawyer because I often feel, yeah, a little bit inadequate as someone who's not trained as a lawyer studying international law. So my journey really is through university and through studies. And as someone who studies the ICTY, I do have a lot of misgivings about my positionality as someone who, it doesn't have connections to the region and really engaged with, the atrocities that were occurring there and justice pursuits through academic research. So that I do often feel a little bit complicated and, yeah, discomforted by how I came to the topic. But really, it sort of began with my undergraduate studies. So I did a Bachelor of International Studies at UNSW, and my major was international relations. So from the get-go, I was always interested in international politics and questions of human rights and justice broadly conceived. And I was doing subjects that were quite broad. So there were international law subjects in the international relations major, which was quite good, like taken from a political perspective as opposed to the more doctrinal approach. I was doing gender studies subjects, development studies subjects, and throughout these, there was always this very encouraging critical approach to these topics. So learning about post-colonial and trail approaches to international law in the Middle East. There was one subject in particular taught by Louise Chappell, actually, on, I think it was called Sex, Human Rights and Justice or something like that. And that was when we looked at a whole bunch of different approaches to gender and justice. And there was a couple of weeks on international criminal law and international criminal justice. And in one of the lectures, we watched a documentary from the ICTY, and it was the one on sexual violence as it's prosecuted at the ICTY. And this was really my first engagement with the ICTY. And, in my early international relations subjects, we had learnt about Bosnia and the wars in the former Yugoslavia, but this really gave a human face to it as opposed to that geopolitical humanitarian intervention, higher level discussions that were being had in those international relations classes. So in this lecture theatre, we're watching this documentary and I'm seeing on the screen witnesses, survivors, detailing their experiences of atrocity, of sexual violence. And I was really quite taken aback and confronted with the horrors of what they had experienced. And in particular for me, something that I think challenged my own assumptions about sexual violence at the time. They were spotlighting the experiences of men who had been sexually violated in the detention camps across Bosnia in particular. And that had always stayed with me long after that class. I then went on to do an honours degree where I was looking at what was I looking at? Gender, as usual, but in the humanitarian private sector space. So looking at how refugees were constructed in kind of gendered and racialized ways. So I always had that kind of attention to gender throughout my studies. And then when it came time to think about, do I want to do a PhD? Is researching something I'm interested in and enjoy? I was thinking, what is something that I could really be sustained by across a 3 to 4 degree and 3 to 4 year degree? And I remembered it stayed with me that time in that lecture theatre where we watched that documentary. It had never left me, the voices of those survivors and the power that a legal setting could provide to have those testimonies heard, at the same time as the limits and how a legal setting might reinforce quite cis heteronormative ideas about shame and stigma and things like that. So I pursued a PhD looking at the ICTY, but very much from a political international relations focus. And there I really brought more of a broader perspective than I had originally imagined. I was originally quite interested in masculinities in that space. And then one of my supervisors said, "What about queer theory?" And that took a whole different turn. And that's taken me to this point where I'm now a lecturer in international relations who researches quite broadly queer approaches to international law and transitional justice. So yeah, I think it really began for me in that lecture theatre where there was a spark or a sense of injustice in me that was sparked, and that I needed to find out more. I think it's quite interesting to reflect back on my ideas then as I don't know, maybe 19, 20-year-old, and how my own assumptions have been challenged through the process. And I'm continuing to challenge myself about how I understand and write on this topic.
Thank you so much for sharing that. I said another really, deep and touching story about how you came to be in international law. Ollie, did you want to add something quickly?
Yeah, I just want to thank you, Caitlin, for sharing this story. And I just want to add, I think it's very important that people who don't have lived experiences, academics and researchers, I don't think it's necessary to have those experiences to contribute to academia and, bring some new ideas and solutions to armed conflict, mass atrocities, their prevention and resolution. I think it's very important that we all we bring different perspectives. We have the same aim, but people who don't have necessarily experiences, they can ask different questions that not those ones with experiences can. And I think people such as myself needed a long time to work on themselves and go through some period of healing and then catch up with the things that have happened. So in the meantime, many other feminists and scholars have jumped in and have done some incredible research and helped the things to move on. So I definitely don't think that's something that's necessary or vital to have, and I think we all have to contribute from different angles and perspectives, and most importantly, asking different questions, because we will, depending on our experiences and perspectives. Thank you.
Yeah, no, thanks, Ollie. Absolutely, I agree with that. We need lots of people to be doing this research, right? Because we're still obviously going through horrible periods of genocide and atrocity. Like, we need every collective mind that we can to work towards this, and listening to and amplifying the voices of people with lived experience is, of course,
Absolutely.
central. But if we can all be working on this, I think the better.
Absolutely.
Okay, so we're going to go from that really, great segue into our main discussion, which is Something we've touched upon in previous episodes of the podcast, and you've both spoken about in your scholarship, which is how courts in international criminal law function as venues of punishment rather than spaces of accountability and justice, which is, if you have argued, Ollie, causes the purported purpose of rehabilitation in criminal law to fall by the wayside. How do these phenomena occur and what are the implications?
So I have become very interested in the question of rehabilitation and reintegration for some time now, watching, primarily observing what's happening in the Balkans with war criminals who have been convicted, sentenced, and returning back home. I don't think this topic has drawn much of attention that I would like it to, but living in the world that we live in, there's so much going on. And I think the former Yugoslavia and the ICTY has received so much attention that, we have the region has been left on its own after the ICTYs was closed. So maybe just to start by reminding everyone that although it was in operation for almost 24 years, neither the ICTY, the Hague detention, nor the European countries where most of the convicted war criminals have been serving their prison sentences developed specialized rehabilitation programs for perpetrators of mass atrocity crimes. Also, Bosnia and other countries in the former Yugoslavia also have no specific rehabilitation programs for war criminals, despite the number of prosecutions and trials that are still ongoing before domestic trials. So we have trials ongoing for the past 20 years before domestic courts. So in Bosnia and elsewhere, convicted war criminals serve their sentences with ordinary, so to speak, criminal population. And apart from counseling, which they can do but do not have to, of course, there is really not much going on. So if there are no rehabilitation programs designed specifically for this kind of prisoner, and I gather it's probably difficult to design one because these are contextual criminals, mass atrocities don't happen every day, or hopefully they won't repeat. But then if we don't have any of rehabilitation programs designed for war criminals, how can we measure really their rehabilitation, those ones who serve their sentences? And how can communities and victims of war crimes come to terms with the idea that war criminals who have not undertaken any rehabilitation have basically a right, which they have, to reintegrate back into society after they serve their sentences for genocide, war crimes, crimes against humanity? So one of the very telling, and I think the former Yugoslavia is great, unfortunately, another great case study of the consequences that this lack of rehabilitation programs is actually that we've seen over there, where over the last 2 decades, many war criminals who returned back home after serving their sentences, they publicly deny their war crimes. The tricky thing is here, and this is what I have been looking really in detail and have published about, is that they're actually denying their crimes has secured their rehabilitation. So the notion of rehabilitation has been completely turned around, because the only way that you can rehabilitate and reintegrate if you are a war criminal is that you deny your war crimes, because none of the communities is owning their war crimes. So everyone is victim, no one is perpetrator, or the other is the perpetrator. So everyone needs to remain a victim, even a war criminal, So denying crimes has become basically paramount if one wants to be reintegrated back into their ethnic community. So I think this is a phenomenon to be studied, right? So rehabilitation became secondary to courts, international courts, domestic courts, penal objectives, particularly punishment and deterrence. So although rehabilitation is recognized as one of the purposes of punishment in international criminal law, it has received considerably less scholarly and practical attention than retribution, deterrence, and really expressive justice. So I think in, public opinion mind, rehabilitation is really often understood narrowly as successful completion. This is how it's represented, as successful completion of a prison sentence and reintegration into society, rather than a process of genuine moral transformation. So as a result, many individuals convicted of genocide, crimes against humanity, war crimes, are or have been released prior to 2020 without acknowledging responsibility, expressing remorse, or apologizing to victims. And there is a kind of disinterest, I have to say, of both the international courts and local judiciary in this fourth pillar of criminal justice, rehabilitation, and social reintegration. And, we can talk why is this the question. It may be reinforced by several factors that International Criminal Tribunals, they really have limited mandates and resources, so very little capacity to provide kind of long-term rehabilitative interventions or post-release, any sort of supervision. Yeah. Then convicted perpetrators, they frequently return to political and social environments, as we've seen in former Yugoslavia, in which denial, as I mentioned, of atrocities is widespread, and also where they are welcomed as heroes rather than condemned as war criminals, as long as they deny their war crimes. So there is no remorse, there is no apology. And only if you don't remorse, don't apologize, you are not ostracized. So in these environments, they reward denial rather than accountability. They discourage expression of remorse, and they reinforce narratives of victimhood and historical revisionism. So this is what's going on, and the ICTY is not the only one. I think we've seen with Thomas Lubanga, the first ICC convict, who also returned to back to his home country, and he did sort of apologize to his victims and but he never personally acknowledged culpability for conscripting child soldiers. So he basically, after serving 14 years of his sentence, on the same day of his release, he publicly stated that he is actually not that cruel and heartless person as the ICC portrayed him. And he now has his own, again, paramilitary forces and new paramilitary army. So what we've seen is that, and what's concerning is that without any sort of rehabilitation and post-conviction, let's call it supervision, most of these war criminals do continue basically with the same ideologies, the same mindset, and basically saying that they are proud. And I can give you a number of examples I want to, of people who served their sentences for crimes against humanities and genocide, and who returned back to the former Yugoslavia and who said they would do the same again, including Biljana Plavšić, that I just wrote a book about, who said that if she had a chance, she would do absolutely the same again. So, so what is then rehabilitation? Is it just serving the sentence, or is something more? And we haven't seen anything more apart from serving the sentence so far. I may stop here and then maybe say a few more things later.
Caitlin, do you want to kind of build on that?
Yeah, I mean, very briefly, because I think Ollie's covered some really important points and probably is more of the expert on this. But I think from my perspective, looking at the ICTY, and as someone who is very overly critical perhaps of it, and much of my research is a critique of the ICTY and the violences of international law. Something that I've had to reckon with as a scholar is calls from victims and survivors and affected communities who want punishment, who want to see war criminals held accountable at the ICTY, put behind bars, that to them is justice. At the same time, of course, there are others within those same groups who do not support the ICTY and do not see it as a form of justice. But I'm thinking here of the group, the Mothers of Srebrenica, who a lot of them have said, that that's justice for us, seeing the perpetrator punished, and they haven't seen that because, of course, the ICTY is an international criminal law tends to prosecute the higher level, the big fish, for the most part. So the more ordinary perpetrators, the everyday, atrocity, people who commit atrocities are often missed out from that narrative. So I think there's a form of symbolic justice that international criminal law could provide, that expressive value. So I do want to acknowledge that, but I do think that for many people, it has been a source of injustice because, as to what Ollie said, punishment is, it's just that one process. And if you don't have the meaningful forms of rehabilitation or the acknowledgement of responsibility, that what does that mean afterward? So, of course, the ICTY closed its doors in 2017. That shouldn't mean that justice stops there. And I think, justice can actually never really be achieved for a lot of these communities, because if you've lost a family member, you've lost friends who have been killed in these wars, there's no justice without your loved ones, right? Like nothing can actually be done to rectify that. So it's a little bit complicated for me because I am predominantly a critic of the ICTY and of international criminal law at providing any sort of justice. But I do think that it's important to acknowledge that there are people who have wanted that punishment, but have also been disappointed by what that can actually offer.
If I can just quickly add two things. One is that a lot of the small fish, a lot of the perpetrators, in particular for genocide in Srebrenica, have been prosecuted, convicted before domestic trials. One of the things that is not many people, I think, and there are many reasons why people don't follow domestic trials, not even local people and journalists anymore, really. It's kind of not of interest to many people to follow that, and many of the judgments haven't been translated, etc., etc. But there have been dozens of people who have been prosecuted for genocide in Srebrenica before domestic courts, I have to say. There has been also, however, around 500 people who escaped justice, who fled, and who are in the neighboring countries and elsewhere. Among these 500 are also people who allegedly committed the genocide in Srebrenica. However, I think that I don't know what's most disturbing. I can't make hierarchy here because a lot of things are disturbing, but the thing is that I really struggle with is that even those ones, this is not in their defense, but it sounds as it is, or it is, even those convicted war criminals who wanted to apologize or who did apologize in remorse, and this is important for survivors, they really cannot do in these environments because they are automatically ostracized. And we know people, war criminals, who some of them have committed suicide after remorsing and apologizing, and some of them have been completely shunned. So they have to choose between these two. Yeah. So, but this is what we are having in this socio-political environment, who created these conditions that it's impossible for people to honestly remorse. So there are so many issues with how did we get to that stage? And I think it's, there are other countries, of course, where war criminals deny, but I think there is something peculiar, something specific to the former Yugoslavia, where you have war criminals allowed to be in public life, being on, media. It's a state-sanctioned denial where people can, come up on the TV shows and media and just publicly deny genocide and war crimes with impunity. So this is what's happening over there. It raises issues around legitimacy of courts as well.
It does, and it brings us to our next question, which builds on this, which, Caitlin, you've written a lot about this in international criminal law, and that's the ICL courtroom as a site of violence, in opposition to ICL's claim of bringing order back to the chaos that the violence has created. How do we assess this reality of violence of the courtroom against the claims of international criminal law?
Yeah, thank you. I think really important to first of all measure up the claims against the violence. So, what are ICL's claims? And there are many, of course, and many are unstated but implicit, and many are very much explicitly stated. If we take the ICTY as an example, it was, of course, established through the UN Security Council, which, under its authority, is, meant to serve international peace and security. So we already begin with that quite lofty claim that that's what international criminal law can do. It can uphold international peace and security. But there are also the more, I guess, specific claims related to international criminal law of seeking criminal accountability, holding individuals responsible, prosecuting violations of international humanitarian law. And, of course, there's the broader claims of, this can be international criminal law could potentially be a source of reconciliation and healing, which I am skeptical of that claim and suspicious of kind of the normative sort of paternalistic ways international law, criminal law is used in that way, but that's perhaps for another time to discuss. So there are those kind of broader claims, and then there might be more specific claims about, for example, we can, prosecuting gender-based violence, or like really being a leader or setting the jurisprudence for particular crimes that up until a certain point haven't been properly engaged with in international criminal law. So if those are the claims, and of bringing justice to victims, because victims are often, increasingly, but perhaps not always, the kind of referent object through which international criminal law is invoked to bring justice to the victims. The violences of international criminal law do not match the claims, in my opinion. And I bring to this from my book that I published in 2025, where I conducted a queer analysis of the ICTY. And for me, that was really about drawing attention to how gender, sexuality, and violence manifest in the tribunal, and in particular, looking at the cis heteronormative and civilizational discourses and logics through which violence is represented in these international legal settings. And perhaps unsurprisingly, my findings were that international criminal law does reproduce these cis heterosexist civilizational or orientalist ideas of particular populations, and it can't really provide the justice that a lot of populations are seeking. And so I identified, I guess, three kind of broad ways that this violence can manifest in the courtroom, at least from my reading of trial transcripts and trial judgments. The first one is legal victimization. And so here what I was seeing is that the victim subject in international criminal law is often constructed in ways that feminize the victim, homogenize the victim, and silence them. And so I can't really go into too much detail for each of these, but just as a brief example, the feminizing of the victim, it could be the reproduction of women as only ever sexual violence victims, as completely ruined by sexual violence, when people like Karen Engel have discussed how there are many other violences and experiences beyond sexual violence that can be equally, if not more, traumatic for people. There's also the reproduction of the cis heterosexual legal subject. So gender diversity, diverse sexualities, anything that is not cis and straight is yeah, not seen in international criminal law. And some people might say, well, the ICTY was a product of the 1990s. This was not something that was talked about, but we know, of course, that that is not true, that crimes against queer people have been occurring for millennia. But it was also something that was discussed back in Nuremberg, or we observed at least crimes taking place by the Nazis with queer persecution. So there's that silencing of non-normative experiences of conflict, which I see as an injustice and a violence of international criminal law. And I do want to point as well to the silencing component, the silenced victim, because we can have, I guess, two arguments to that, that international criminal law and courtrooms can be a site for victims to tell their stories. It can be empowering for some, but for a lot of people, it can be really disempowering and dehumanizing when the lawyers, the defense attorneys, the judges are trying to condense their stories into legalese and to uphold whatever charge they're trying to seek for the perpetrator. So again, that's a tension between the human justice and the procedural justice of the court. Then the two other forms of violence that I wanted to talk about were denunciation. Really, this is the demonization of the perpetrator. And for me, what is quite problematic is, again, the ways that, at least at the ICTY, perpetrators were constructed as particularly savage, vicious, in ways that lent on ideas about the former Yugoslavia as a place that is, in air quotes, backward, non-European, uncivilized. So there's some really problematic logics, as you can tell, that underpin that and that really provide, reproduce this quite, yeah, I would say backwards understanding of the former Yugoslavia. So that to me is a violence, an epistemic violence, and it's one that is part of a broader pattern of international governance and intervention in the region that has taken that quite top-down paternalist approach. And that leads me to my third violence, which is paternalism. And so you do see that quite father figure element coming in where the law is the moral intervener, that they can, after the fact, save the former Yugoslavia through justice. And again, I think that this is a problematic way of seeking justice that does deny the complex wants and realities of people in the region. So to me, all of that does not stack up against international criminal law's claims. But before I pass it over to Ollie, I do want to mention something else which I think is important given this morning I read an article where the survivor of who's accusing Karim Khan of sexual misconduct has gone public. And to me, this is a really important case of we need to be listening to survivors. And I think that has been a little bit lost in the narratives about the misconduct allegations against the prosecutor. I think a lot of fascist and authoritarian states critical of the International Criminal Court has weaponized that to really attack the prosecutor. But I think it's so important that we look at this instance as a case of how violence manifests in international criminal courts. It's seen as such an exceptionalized microcosm. And given the lofty ideals of international criminal law, where they are trying to prosecute crimes of gender-based violence, that it's deemed unthinkable that the prosecutor could actually be engaging in this himself. So this, to me, is another instance of how violence materializes in the courtroom. So I think, yeah, really important that we are critical of them and bring them to light. Yeah.
Yeah, I read that article this morning as well.
Mm.
It was a lot. Ollie, did you want to chime in on this question of the violence of the courtroom?
Just quickly, just to add, I think I absolutely agree with everything what Caitlin has to say. And I think we need to really start learning lessons from some things, because these all have long-term consequences. So people who were portrayed as kind of sole victims, they stay victims. That victimhood is kind of cemented. And it's also, bit dangerous to being all the time in that sort of position, and feed into that position and continuously work just from that position. So it becomes a problem to move somewhere else. And the same with perpetrators. And I think I just want to say about perpetrators that those war criminals who were prosecuted by the ICTY, they have such a spotlight on their lives. So no one knows about those ones who were convicted. There were hundreds, 700 or 1,000 people convicted before domestic trials, but they never had even local attention, let alone international. But for those ones who were prosecuted before the international courts in the ICTY, everyone knows their name, kind of. So it's a very different position that they have in society in terms of, again, whether if you want to go back, how to rehabilitate and reintegrate those ones who were prosecuted before local courts. So they had this kind of different spotlight. The same with the victims. And I think it's very problematic. I also wrote about silenced victims, looking at which ethnicities of women were, the major victims of, for example, sexual violence. And then the other ethnicities are not there, although, everyone kind of suffered to different degrees, of course. I will just leave it there.
Yeah, thank you. That's a really kind of valuable addition to this conversation, so I really appreciate that. Moving on to kind of our last substantive question. One of the perennial debates among feminists tied to all of these issues, and something you've addressed in your recent book, Madam War Criminal Ollie, is how do feminists respond to women who commit atrocity crimes? I've argued alongside Joanne Sagg and Stacey Henderson in the context of the Abu Ghraib atrocities that holding women to account for these actions in this space is a feminist act, but one that many feminists have been reluctant to engage in. What do you both make of this problem?
I think definitely there is a hesitance among among feminist scholars to research women perpetrators and in studies of war, genocide, political violence. Even when it's mentioned, it's usually this women's participation in these crimes and violence has been frequently minimized, exceptionalized, or explained through manipulation by men, by coercion, or their emotional instability rather than agency. I think take my book, Madame War Criminal, I tried some, or I didn't, I knew that feminist publishing houses didn't want to engage with the book, so we reinforce this narrative, which I understand. It's not that simplistic, and I will come to that. But this reluctance stems from concerns that focusing on women perpetrators might undermine, of course, recognition of the widespread victimization of women, particularly in the context of sexual gender-based violence. So we write extensively about women survivors, but far less about women's capacity to commit crimes. And this reluctance, of course, historically existed for understandable reasons. For a long time, women victims of mass atrocities, as we know, were completely silenced, overlooked in research, in histories of war, and significant effort really was required to bring those experiences into public and scholarly view. So, however, the hesitance to engage with women's agency in committing crimes, remains as a result under-researched and kind of shunned. Another reason I think why feminist scholars in particular avoid, looking at women perpetrators is kind of to avoid feeding into this misogynist narrative, such as, you see women can be nasty too. So kind of giving food for those kind of arguments and the commentaries. Even, that we know that women perpetrators remain, of course, not of course, but they do remain minority compared to men. So, and And also women such as Plavšić, Biljana Plavšić, was attacked definitely more fiercely by the media and commentators because she was a woman, yeah? So no man, they were called, some of them, monsters, which I also completely disagree, but no man was called, for example, male Mengele, but she was called female Mengele. She was called divorcee, she was called childless because she didn't have children, and all sorts of nasty names. A lot of media was, doing commentary on how she was, on her clothes, etc., her look, usual stuff. So, but I think there is this kind of fear of reinforcing these false equivalences that, again, mostly misogynists might exploit to claim that women are just as evil as men. I'm doing here quotation mark. So at the same time, feminist scholarship has increasingly argued that excluding women perpetrators really reproduces simplistic understanding of gender and violence. Yeah, and because women as men, they can and they do occupy simultaneously, often multiple roles. They can be victims, but they can be also bystanders, perpetrators, collaborators, informers. And these categories are even not always mutually exclusive. So I think this question really raises a long-standing tension within feminist theory and practice, how to reconcile commitment to gender equality with the reality, and to, advancing and bringing justice to long silence women experience with political violence, but how to reconcile that with reality that there are women who perpetrate serious violence, yeah, including international crimes. So holding women accountable for crimes they commit is, I think, feminist act, because feminism seeks equality before the law and rejects essentialist assumption that women are inherently more peaceful, caring, and morally superior than men. Yeah. So to exempt women from accountability simply because of their gender reinforces these very stereotypes that feminism has long sought to dismantle.
Yeah, I agree. And the paper I've done with Joanne and Stacey, we argue exactly that accepting women's full agency also means accepting when women use that agency to do terrible things. Caitlin, do you want to build on this?
Yeah, very briefly. I won't repeat anything that Ollie and Tamsin you've said, because I agree 100%. Those problematic essentialist notions of, women as inherently peaceful, and so they're thus 10 times more monstrous when they've committed crimes, right? Like, it's obviously very problematic. And so to me, I do agree that feminist analyses are so important for shining a light on women who perpetrate crimes and holding them to account. But at the same time, I guess the question is, what feminism are we talking about here? And a critical feminist perspective does bring those problematic questions to light. But then, there are also feminists that are more supportive of international criminal justice, who use that to say, okay, we need to who are broadly supportive of the International Criminal Justice Project and the carceral system. And so, if we turn to abolition feminism, it would actually, the question would be, well, it's not feminist, because a feminist world is when, we do away with the carceral system completely. And this is perhaps not the justice that we're seeking, but accountability in other ways might be more important, right? And so for me, I compare this question to a little bit of how I see debates about gender equality and inclusion in the military, for women in the military, and gender diverse people in the military. And, a kind of like liberal feminist argument would be, yes, like, of course, we need to have equality, and women and gender diverse people should absolutely be allowed to join the military if they want to. But then the abolitionist and anti-militarist part of me and feminists would say, well, the military is an inherently violent system. Why do we want to seek inclusion in such a violent project? So I'm in two minds about it. It's like, what feminist world are we wanting to bring into being? And I think we can hold both of those tensions together, that we can see that when we've got a system like international criminal law, it can be a source of justice for some. And so we should absolutely be, yeah, investigating all people as perpetrators. But at the same time, after I've just talked about all the violences of international criminal law, is this necessarily the most justice seeking mechanism to do it?
Yeah, look, and I personally would agree with that. I sit here as an abolitionist feminist and saying that holding women to account for their atrocities is a feminist act, but I agree. The question is, what accountability should we be applying to everyone who's engaging in atrocities? So, yeah, it's complex. I'm not denying that, and there's a whole bunch of questions around what do we want and how do we deal with what we have at the same time. Yeah. Now, we're going to move to wrapping up, unless you have one last thing you want to add to that, Ollie.
No, I'm
No.
also a transitional justice scholar. Maybe
Yeah,
so. It's just, of course, there are other mechanisms to, that
Yeah.
can be deployed, and international criminal prosecutions are definitely not the only answer, or maybe also for me, not the first answer. So there are other
Yeah.
mechanisms that we have to look at.
Yeah.
yeah,
So, in wrapping up, we normally ask a non-international law question about escape routes, what you're reading, listening, or doing that takes your mind off international law. But in season three, I've been given a free hand on this question, and so as a former chef, I'm asking all about food. So, Ollie and Caitlin, tell me, what is your ultimate comfort food? Where can you get the best version of it? And where can listeners find a solid recipe to make it at home?
As I said to you, Tamsin, this is the most challenging out of all questions for me. I love eating. I don't like cooking, and the best food I can find in my kitchen, made by my partner, who is the main chef in the house. So he is the one who does all the cooking. But maybe something very traditional. The food is. When I think about food and what we like to eat also in our household and with our friends from the Balkans, it's usually the food that is connected to where you come from originally, from your childhood, and it's more connected to nostalgia really than anything else. This is why it's comfort, because you eat something that reminds you on your home, your childhood, your friends, etc. So to cut so maybe Bosnian pie or cevapi. Cevapi is traditional grilled minced meat. It's a meat dish from the Balkans, and you usually eat it with a piece of kind of. It's not really bread. It's called somun. But that's how it's eaten, and it's something that if you go to former Yugoslavia, you can find it really everywhere. It's one of the most favorite food for the people who are coming from this region. So, and I think you can also, of course, you can buy it also in shops around here in Australia. I mean, if you want to try.
Fantastic. Caitlin?
yeah. In contrast to Ollie, this was perhaps my favorite question. Given we were talking about such traumatic material, it's nice to end on this palate cleanser. For me, so I love cooking, and probably because I'm a vegan and my partner's not a vegan, so uh, it really helps to have a good bunch of recipes under your belt. For me, my comfort food is a good dal. I love a dal tadka. Uh, there was this Indian restaurant just around the corner that used to make a really nice one. Typical, they closed down. So I haven't been able to find a really great dal at other restaurants since. But as is the vegan's life, we try to cook all of these really tasty recipes that you can't find out in the world of restaurants. So I would recommend it's a website called Rainbow Plant Life. Their dal tadka is really nice. But if you're going to make it, please get all of the ingredients. Like make sure you get the proper moong dal, like get all the spices. They're readily available at Indian supermarkets. So that gives the best like restaurant quality flavor of a dal tadka. But yeah, curries are my go-to comfort food.
Fantastic. Well, thank you both so much for the conversation, and for the wonderful food pun with the closing question there, Caitlin, as well. And to our listeners, we will catch you next time. Bye bye.
Thank you. Bye.
Okay.